In the recent past, there has been an increase in immigration enforcement. Many undocumented people have found it more difficult to live and work in the United States. In 2005, the Real ID Act made it impossible to get a driver's license without proving legal status. Recently, a law called the Secure Communities Act enables local law enforcement to provide fingerprints of those arrested to both the FBI and immigration officials.
A foreign national is considered out of status when he enters the United States illegally or when his visa has expired. Immigration will most likely initiate a removal proceeding or the deportation process if officials arrest or catch individuals who are out of status. It is important to know that people being placed into removal proceedings for the first time are entitled to a hearing before the court to determine what options they have, but that right can be forfeited or waived. Sometimes people give up that right to a hearing without realizing they may be eligible to cancel the removal proceedings and obtain residence. Police or the immigration officers cannot automatically deport people unless they have been previously deported or under some circumstances involving very serious criminal charges or security concerns. The only way that you can be deported if you have not been previously removed is if you agree to a deportation or an immigration judge issues an order of removal.
Not all removals at the border are deportations. If you are detained at the border and are simply returned to your country, it may not necessarily be a deportation. Consult with an immigration attorney.
The most common way undocumented individuals come into contact with immigration officials is as a result of driving offenses, including alcohol-related offenses or domestic violence. For example, if an officer stops you when you're driving a car because he has probable cause to believe that you've violated a law or ordinance and you're unable to present a valid driver's license, the officer does have the right to arrest you and take you into custody. International driver's licenses are not valid unless you have legal status and have not established residence in the state in which you live.
If you are taken to a local jail, your fingerprints will be taken and sent to Immigration and Customs Enforcement, or what is known as ICE. If you do not have legal status, they will place an immigration hold on you. An immigration hold means that the jail can hold you until ICE picks you up, but for no more than 48 hours, excluding weekends and holidays. It is very important to understand that the 48 hours will not start until you have met all local custody conditions. That means you must pay your local bond, complete your jail time, or otherwise satisfy the terms of your sentence.
For example, let's say that you get arrested on a Thursday night for driving under the influence of alcohol. A police officer arrests you and takes you to the local jail. They set a local bond of $250 for you to be released. If you do not pay that bond, the 48 hours will not start. Jail officers may not permit the bond payment or recommend that there is no reason to pay it because ICE will pick up the detainee anyway. This is incorrect. You should consult with an attorney because it is usually better to pay the bond immediately. Paying the bond is often necessary in order to start the 48-hour time limit and restrict the time for immigration to get involved. If you pay your bond on Thursday night, because weekends don't count for the 48-hour period, immigration will have until Monday night to pick you up. If Monday was a holiday, then the 48-hour period would not expire until Tuesday. If the jail holds you for more than 48 hours and you have met all local conditions, then your attorney can insist that the jail release you. Once ICE picks you up, officers will transfer you to the local ICE office and take your fingerprints to verify your identity and whether there are previous immigration issues. There are 3 possible outcomes from your immigration detention.
If you do not have significant criminal issues, you will likely be released the same day with no bond. This is called being released on your own recognizance. If you have any criminal history, such as previous alcohol-related offenses, you will be required to pay a bond at a designated office to be released, and the payment of that bond should be done by an individual with legal status. Your attorney can help you with that process. And keep in mind that criminal history will affect bond determination, even if you paid all fines, served jail time, or it happened in a different state years ago. Immigration considers all criminal conduct when determining bond, even if a conviction is expunged from your record.
In both of these scenarios, ICE will give you a document called an NTA, or Notice to Appear. This document means that you will have to present yourself at a hearing before the immigration court. The judge will ultimately decide whether you can stay in the United States. If you are unable to pay your bond, you will have to wait in custody for your hearing.
If you have serious criminal offenses, such as violent crimes, crimes involving fraud or deceit, a drug-related offense, you may be mandatorily detainable. That means that you will not be eligible for bond and that the immigration officials are prohibited from releasing you. Instead, you will likely have to fight your deportation case from jail. You should still consult with your attorney to make sure that there are no forms of relief available before you give up and waive your rights and agree to a deportation. But avoiding deportation will be more difficult with serious criminal convictions. Your attorney can explain your options, including asking that your deportation be carried out as quickly as possible to prevent unnecessary detention. If you have been deported previously, immigration officials will most likely carry out your removal without a hearing. But you should consult with an attorney to make sure that your case cannot be reopened.
Consult with an immigration attorney now if you have previous criminal offenses or previous deportations. Although difficult, people with criminal offenses may be able to address them through a process called post-conviction relief. People with previous deportations may be able to reopen their cases if there is a legal basis to do so.
It is important to know that ICE officials may give you a document called a stipulated removal agreement. If you sign this document, you are agreeing to be deported. Many people who may have qualified to remain in the United States have been deported after signing this document. You should always consult with an attorney before you sign this document to make sure you have no other options. There are some documents that you must sign while in immigration custody. One is your fingerprint card or custody determination, and the other is acknowledging receipt of the notice to appear or NTA. Some people refuse to sign these documents because they are fearful. However, this refusal can be seen as a failure to cooperate and cause immigration to increase your bond or decline to even set a bond at all. Having counsel present to explain what you should and should not sign is best. If immigration refuses to set a bond or permit your release, your attorney may petition the immigration court to set a bond. This will cause unnecessary delays and expenses that could have been avoided if you had simply signed documents and cooperated. It is important to have representation so you can be cooperative with immigration and understand that you are being asked to sign. Part of being cooperative with immigration is being truthful. For example, you should always give your real name and disclose if you have been caught at the border and fingerprinted. Immigration will likely have access to those records, and lying about it may make your situation worse.
Unless you sign a stipulated removal agreement or meet the other conditions we discussed, you will have a hearing before the immigration court. The immigration judge will decide whether you should be deported, or if you have options for relief from removal, including voluntary departure. Some, however, will be eligible to apply for immigration benefits. The only way you'll know this is if you have a thorough review of your case by an experienced attorney. Relying on the advice of friends who may have been through this process or know somebody who has, or relying upon the advice of attorneys or others who don't regularly practice in this area would be a mistake. Many people make their situation worse or even deported due to mistakes such as filing paperwork they should not have filed, after following bad advice from notarios, other people not licensed to practice law, or inexperienced attorneys.
Remember that every case is different in that some people may have other options through family members or employment. Talk to your immigration attorney to know your options before you are detained and have a plan for any situation.